Hi, I'm Dahlin. I'm an attorney in Lincoln, Nebraska. I wanted to talk to you about will contests. Sometimes you could be a relative of a person or an heir that would normally take from that person, but maybe you find out that the will doesn't give you anything and you think that that's wrong. There are methods to looking into whether the will is valid and contesting a will. There are several requirements for a will to be valid. Those are set out in each state's statutes. In general, it has to be duly executed, which is there needs to be a certain number of witnesses and a notary for the person when they sign the will. Also, the person has to have testamentary capacity or be of sound mind to do a will where they know who would normally take from them, from their estate, and what their estate consists of, what property they have. There are grounds that can make a will invalid, such as undue influence. If a person has exerted undue influence in having the person do a will that is leaving people out that they otherwise wouldn't, that would be a product of undue influence. This happens more often if the person is older, more frail, and somebody that has access to them is able to exert influence on them that isn't proper. There's also duress, which is basically forcing a person to do a will, and there's outright fraud that can make a will invalid. If you have a situation where a relative has passed away and you believe you would rightfully be in the will, and there's circumstances that you believe may not be right with the situation of the will, please feel free to contact me at 402-423-4300 to discuss your situation.